My name is Dr. K.P. Asha Mukundan. I teach as a faculty in the Tata Institute of Social Sciences, School of Social Work, Center for Criminology and Justice. Today, we are going to look at the topic on legal aid in juvenile justice system. This is a part of the course on criminology under the paper of juvenile justice system. The objectives of this course or this module is to understand the concept of legal aid in juvenile justice system, to understand the working guidelines of the legal aid functioning in juvenile justice system, and to appreciate the socio-legal functioning in the entire system. This module will be looking at the Legal Services Authorities Act of 1987, the various hierarchy of bodies created under the Act, the Legal Aid Act in the juvenile justice system, and the guidelines for legal aid services in the juvenile justice institutions as per the Sampurna Behrua case versus the Union of India, and it will also look into the current developments and finally conclude by looking at the way forward. To begin with, the Article 39 of the Constitution of India provides for principles of policy to be followed by the state. It states that the state shall in particular direct its policy towards securing 1. That children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and the childhood and youth are protected against exploitation and against moral and material abandonment. Article 39A of the Constitution emphasizes on equal justice and free legal aid. It states, the state shall secure that the operation of the legal service system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable legislation of schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. The crucial words in the principles contained in Article 39A are the obligation of the state to provide free legal aid by suitable legislation or by schemes of in any other way, so that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Article 14 and 22(1) also make it obligatory for the state to ensure equality before law and a legal system which promotes justice on a basis of equal opportunity to all. Legal aid strives to ensure that constitutional pledge is fulfilled in its letter and spirit, and equal justice is made available to the poor, downtrodden and weaker sections of the society. Let us look at the Criminal Procedure Code. Under section 304 mentions that it is the constitutional duty to provide legal aid at state expense which arises from the time the accused is produced before the magistrate for the first time and continues whenever he is produced for remand. Besides this, Article 8 of the Universal Declaration of Human Rights, also known as UDHR, states, everyone has the right to an effective remedy by the competent national tribunal for acts violating the fundamental rights granted by the Constitution or by the law. Article 14(3) of the International Covenant of Civil and Political Rights guarantees to everyone the right to be tried in his presence and to defend himself in person or through legal assistance of his own choosing, to be informed if he does not have legal assistance, of his right and to have legal assistance assigned to him in any case where the interest of justice shall require, and without payment by him in any such case if he does not have sufficient means to pay for it. India is a signatory to the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. In 1980, a committee under the chairmanship of Honorable Mr. Justice P.N. Bhagwati, then Judge of the Supreme Court of India, was set up at the national level to oversee and supervise legal aid programs throughout the country. This committee came to be known as CILAS, that is Committee for Implementing Legal Aid Schemes, and started monitoring legal aid activities throughout the country. In 1987, Legal Services Authorities Act was enacted to give a statutory base to the legal aid programs throughout the country on a uniform pattern. This act was finally enforced on the 9th of November 1995 after certain amendments were introduced therein by the Amendment Act of 1994. The Legal Services Authorities Act 1987 clearly fulfills the state mandate stated in the Article 39 and 39A of the Indian Constitution, and it clearly states that legal services authorities are constituted to provide free legal services to the weaker sections of the society to ensure that justice is not denied to any citizen due to reasons of economic or any other disabilities. Now, we will look into the salient features of the Legal Services Authorities Act of 1987. Section 12 of the Legal Services Authorities Act 1987 laid down the list of persons who are entitled to legal services. It includes A. A member of a scheduled caste or scheduled tribes, B. A victim of trafficking in human beings or beggar as referred to in Article 23 of the Constitution, C. It also talks about a woman or a child, D. A mentally ill or otherwise disabled person, E. A person under circumstances of undeserved want such as being a victim of a mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake or industrial disaster, or L. An industrial workman, or G. In custody, including custody in a protective home within the meaning of clause G of section 2 of the Immoral Traffic Prevention Act 1956 or ITPA as it is known as, or in a juvenile home within the meaning of clause J of section 2 of the Juvenile Justice Act 1986, or in a psychiatric hospital or psychiatric nursing home within the meaning of clause G of section 2 of the Mental Health Act 1987. H. In receipt of annual income less than rupees 9,000 or such other higher amount as may be prescribed by the state government, if the case is before a court other than the Supreme Court, and less than rupees 12,000 or such other higher amount as may be prescribed by the central government, if the case is before the Supreme Court. Section 13 of the Act further states, persons who satisfy all or any of the above criteria that is specified in section 12 shall be entitled to receive legal services provided that the concerned authority is satisfied that such person has a prima facie case to prosecute or to defend. An affidavit made by a person as to his income may be regarded as sufficient for making him eligible to the entitlement of legal services under this Act, unless the concerned authority has reason to believe such affidavit has reason to disbelieve such affidavit. The free legal services include payment of court fees, process fees and all other charges payable or incurred in connection with any legal proceedings, providing service of lawyers in legal proceedings, obtaining and supply of certified copies of orders and other legal documents in legal proceedings, preparation of appeal paper book including printing and translation of documents in legal proceedings. Let us look at the hierarchy of bodies that have been created under this Act. It speaks about the National Legal Services Authority, also known as NALSA, which is the apex body constituted to lay down policies, principles, guidelines and frame effective and economical schemes which can be implemented through the State Legal Services Authority, also known as SALSA, in order to make legal services available to all. It also disburses funds and grants to state legal services authorities and NGOs for implementing legal aid schemes and programs. In every state, a state legal service authority is constituted to give effect to the policies and directions of the central authority or NALSA. It is mandated to discharge the following main functions on regular basis. 1. To provide free and competent legal services to the eligible persons. 2. To organize lok adalats for amicable settlement of disputes. And 3. To organize legal awareness camps in the rural areas and to give legal services to the people and conduct lok adalats in the state. State Legal Services Authority, also known as SALSA, is headed by the Chief Justice of the State High Court, who is the patron-in-chief. A serving or retired judge of the High Court is nominated as its executive chairman. District Legal Services Authority is constituted in every district to implement legal aid programs and schemes in the district. The district judge of the district is its ex officio chairman. Taluk legal service committees are also constituted for each of the taluk or mandal or for groups of taluk or mandal to coordinate the activities of legal services in the taluk and to organize lok adalats. Every taluk legal services committee is headed by a senior civil judge operating within the jurisdiction of the committee, who is its ex officio chairman. Primarily, the State Legal Services Authority, District Legal Services Authorities, Taluk Legal Services Authorities, etc. Now, let us look at the legal aid in the juvenile justice system. With all its system in place, the State Legal Services Authorities or SALSA work has concentrated more towards providing legal aid to adults. The juvenile justice functioned with the help of a probation officer who was the legal cum social officer in the system. It was a probation officer who used to produce the child before the Juvenile Justice Board, present the case and assist the child in conflict with law for all social and legal matters. Private lawyers used to function, but their presence was less than that of the POs. With the passing years, the working of the POs got diluted due to various functions and their void was then occupied or filled by the private lawyers. The increase in the number of private lawyers representing juvenile cases or CCL cases resulted in exploitation of children. It was seen that there is a nexus between the police and the private lawyers, and the children are advised to appoint lawyers at the police station itself. The police officer would play the Samaritan by also referring the CCL to a particular lawyer for which he or she would get a commission for the same. Besides this, it was seen that the lawyers who practiced in the juvenile justice system advocated for adult-like practices of procedures before the JJB. Their main focus was of the legal case and not on the rehabilitation of the CCLs, which is the prime objective of the Act. Given these and many such challenges, in October 2011, the Supreme Court in Sampurna Behrua versus Union of India, a public interest litigation, directed the Director General of Police of the states to designate one police officer in each police station as juvenile child/welfare officer. The court directed legal services authorities to train such police officials and give free legal services to all children in conflict with law on an incremental basis, starting with the state capital cities. In the order dated 19/8/2011, Honorable Supreme Court of India in Sampurna Behrua versus Union of India directed the National Legal Services Authorities to put in place legal aid centers attached to the juvenile justice boards in the state's capital, where there is a high pendency. The order further states that the State Legal Services Authority is requested to establish legal aid centers attached to the Juvenile Justice Board in the state union territory capitals immediately. For this purpose, the following steps may be taken immediately was what the state said. The State Legal Services Authority may direct the District Legal Services Authority of the capital districts to establish legal aid centers in the juvenile justice boards working in the capital city. Next, the aforesaid DLSA may be directed to prepare a list of young panel lawyers for such legal aid center. The panel lawyers may be selected from young and competent lawyers, preferably women, or preferably women lawyers who are willing to work the entire day in a child-friendly manner in compliance with the spirit and object of the Juvenile Justice Care and Protection of Children Act 2000 and now the amended Act 2015. The same set of lawyers was also to be made available for legal aid in CWCs and in the different homes established under the Act whenever necessary. It stated that the arrangements may be made by the concerned DLSA to organize a training camp for the aforesaid panel lawyers on the juvenile jurisprudence, focusing on the philosophy behind the UN Convention on the Rights of the Children and their provisions in the JJ Act 2015. This was done with a special emphasis on the principles enumerated in Chapter 2, Rule 3 of the Juvenile Justice Rules of 2007, which is the model rules. Even if the next it stated was, even if there is no infrastructural facilities available in the JJB, the panel lawyer may be directed to attend the JJB proceedings throughout the day on the days when the JJB sits, depending on the volume of work. The number of panel lawyers to be deputed on the particular day may be regulated by DLSA, and they may also send to the JJB on turn basis. However, a lawyer entrusted with a case may be directed to handle it till its disposal. The Act said that the list of panel lawyers containing their names, addresses and contact numbers may be communicated to the principal magistrate and the members of the JJB, and such a list may be exhibited at a prominent place in the JJB, which is painted on a board or on the flex board premise. The order stated a special request may be made to the principal magistrate and the members of the JJB to avail of the services of the panel lawyers and not to leave the children in conflict with law to the mercy and exploitation by others. It further said that the principal magistrate and the members of the JJB may be requested to inform all children in conflict with law about the availability of the free legal aid and about the list of panel lawyers displayed as above. Honorarium at a special rate may be fixed by the state legal services authorities for those panel lawyers who attend the JJB for the entire day. The next direction was that the panel lawyers may, for the time being, be permitted to use the existing infrastructural facilities available in the DLSA or the district legal services authorities. A monthly statistic report of the legal aid given to children shall be submitted to the state legal services authorities, who shall include the same in the statistics, which is usually sent to NALSA. It further said that the guidelines to be supplied to the panel lawyers are annexed in this communication, and copies of the same may be arranged to be given to each panel lawyer. An acknowledgement of receipt of the same may be obtained from them. So, such safeguards were taken to ensure the good functioning of the legal aid. Now, we get into the guidelines for legal services in the juvenile justice institutions as stated by the Sampurna Behrua versus the Union of India case. Some of the guidelines are: 1. When a child is produced before the board by the police, the board should call the legal aid lawyer in front of it, should introduce the juvenile parent to the lawyer. The juvenile and his or her family parents should be made to understand their rights to have a legal aid lawyer and that they need not pay any fees to anyone for this. JJB should give time to legal aid lawyer to interact with juvenile and his or her parents before conducting hearing. Juvenile Justice Board should mention in its order that legal aid lawyer has been assigned and the name and presence of the legal aid lawyer should be mentioned in the order. Board should make sure that a child and his parents are given sufficient time to be familiar with legal aid counsel and get time to discuss about the case before hearing is done. Juvenile Justice Board should also make sure that it's not a single juvenile's case goes without having a legal aid counsel. JJB should issue a certificate of attendance to legal aid lawyers at the end of the month and should also verify their work done reports. In case of any lapse or misdeed on the part of the legal aid lawyers, board should intimidate the state legal services authorities and should take corrective steps. The Juvenile Justice Board and legal aid lawyers should work in a spirit of understanding, solidarity and coordination. It can bring a sea of change if something like this is done. Legal aid lawyers should develop good understanding of the JJ law and of juvenile delinquency by reading and participating in workshops and training on juvenile justice. Legal aid lawyers should maintain a diary at center in which dates of cases are regularly entered. If a legal aid lawyer goes on leave or is not able to attend the board on any given day, he or she should ensure that cases are attended by fellow legal aid lawyers in his or her absence and that case is not neglected. Legal aid lawyers should not take legal aid work as a matter of charity and should deliver the best. Legal aid lawyer should raise issues, concerns, problems in monthly meetings with state legal services authority. Legal aid lawyers are also expected to maintain a file of each case and should make daily entry of proceedings. Legal aid lawyers should not wait for JJB to call him or her for taking up a case. There should be efforts to make or take up cases of his or her own by the way of approaching families who come to JJB. Legal aid lawyers should inspire faith and confidence in children, their families, whose cause they take up, and should make all possible efforts to get them all possible help. Legal aid should abide by the terms and conditions of empanelment on legal aid. Legal aid lawyer should tender his or her monthly work done report to the Juvenile Justice Board within week of each month for verification, and should submit it to the concerned authority with attendance certificate for processing payments. Legal aid lawyer must inform the client about the next date of hearing and should give his or her phone number to the client so that they could make calls at time of any need. As a matter of best practice, the NALSA has now proposed for no Bal Lok Adalats in the Juvenile Justice Board. In its letter dated 2nd November 2016 of the reference number 39/2015, NALSA has communicated to all state legal service authorities stating that holding of such adalats for disposing of case pertaining to children in conflict with law is against the letter and spirit of the juvenile law, and need to work out a rehabilitative mechanism for children in conflict with law. Whatever be the nature of the offence they are alleged to have committed, while the intent behind holding such adalat is to ensure expeditious disposal of cases of children in conflict with law, the same cannot be done against the basic premise the child are to be treated differently, and that before disposal of a case, the Juvenile Justice Board should interact with the children, look at social investigation report, and incorporate an individual care plan in the disposal order. In this context, the practice of holding Bal Lok Adalat or Bal Samvad Adalat, the Bal Lok Adalat for disposing of cases pertaining to children in law, has to be discontinued forthwith. Let us look at the way forward from here. The Juvenile Justice Care and Protection of Act 2015 is a socio-legal act. The social and the legal aspect in the act must go hand in hand. This is the reason why the Juvenile Justice Board comprises of a magistrate and 2 social workers. While it is a positive move to strengthen the legal aid, the apprehension lies in strengthening the legal aid without strengthening the probation system, which might lead to the legalization of the socio-legal act. This is exactly what is happening. While there is an emphasis being laid on disposal of cases, there is little emphasis on rehabilitation of cases, which negates the principle of the socio-legal. To get the JJB function in the true spirit, it is important to strengthen the free legal aid as well as the probation system simultaneously, so that the CCLs or the children in conflict with law can finally benefit out of the same. The Sampurna Behrua case resulted in NALSA to set up a panel of lawyers who are trained to deal with juvenile cases. Given that they are paid well by the state, the element of the economic exploitation is minimized. However, this provision is yet to be implemented in its true spirit across all states. Till then, the challenge of free legal aid continues. A concept of socio-legal cell may be more appropriate than a legal aid in this context. There is not much of information available on free legal aid in the juvenile justice system. We have tried to bring in a few resources and references which have been put up in the module. For further information, one will have to start doing a lot more research studies on this topic. Thank you.